Patrick McQueen. Oh my gosh, thank you so much for visiting with me today. I reached out and I really have been getting a lot of questions about how to take title and what all of these options are that title companies give people when they're under contract to purchase a house. So before we dive into that, for anybody that doesn't know who Patrick McQueen is, he is a local real estate attorney here in the Phoenix metro area and has been a longtime friend and just somebody I look to for guidance when it comes to things residential real estate related, although you do commercial as well. But thank you so much, Patrick.
Oh, my pleasure. Thanks so much for the warm introduction.
You bet. All right, let's just dive into this whole title thing. And by that I mean how somebody that's purchasing a home, how they're going to hold legal title. If there's a deed of trust, the title goes on that deed of trust. But if they're paying cash, they're still having a warranty deed. So walk me through just from your position, the do's and don'ts or the things that people need to consider. And maybe we can just start with the most common ways that people hold title when they're purchasing residential real estate.
Yeah, I'm happy to get into all that. And one of the first things you sort of mentioned was there's a way to hold title, and then there's a separate deed of trust that is a loan document. And those are two very distinct concepts. And a lot of times we get a lot of confusion or confuse people. Well, I signed the deed of trust. I signed it. And it's like, well, how did you take title? Because those are two very different things, right? Taking title is how you accept your deed to title to the property. How you are taking title is going to affect, what legal obligations you may have to others, estate planning, taxation, divorce, asset protection, your ability to sell or partition. Whereas the deed of trust is security for the lender's note. When you sign a note, I promise to pay you this mortgage back. That is secured by a deed of trust. So two totally different concepts. The way I take title is the way I own my property, and then I grant to my lender a deed of trust. So that is getting over that hurdle. That was one of the first things I learned when I started getting into this business. I was like, oh, okay, yeah, deed of trust, totally different. So that's one area of confusion. But the manner in which people hold title, as I said, has so many implications. I guess that's probably the right word. And so when you're faced with having to make a decision on how you take title to a piece of property when you're buying it, or even later down the road when you want to change the way in which you're holding title, it's very imperative that people know exactly what they're getting themselves into. So for instance, sometimes we'll have buddies who are investors together in a project. Well, they can't take title in certain ways, like community property with right of survivorship. You have to be a married couple. You have to have a recognized marriage in Arizona to take title as community property or community property with right of survivorship. So there's and there's different reasons you would want community property versus community property with right of survivorship. So a lot of times, you just knowing that is sort of half the battle. And I prepared a chart. I have a chart. If people want to email me for it, I'm happy to send it out. It's it basically outlines all of the sort of legal consequences of taking title in one way versus the other. But there's so many. You can take title as your sole and separate property, meaning you don't want your spouse that he or she doesn't have any interest in that property, and they have to issue a disclaimer deed, and there's some other stuff that has to go to formalize the way in which you're taking title. So I would say the most common way people take title is community property with right of survivorship, joint tenants or joint tenants with right of survivorship, and then tenants in common. Those are the basics. But then we get into sole and separate property, which is another way to take title. You can take title in the name of an entity or a trust. So in the name of an LLC or a corporation or a trust as well. And so each one of those has certain unique things that you can and can't do. For example, another example of how these things are different. Let's say that my wife and I take title to our property as community property with right of survivorship. Okay. Well, let's say I want to sell the property and she doesn't. The way in which I can sell that property is I have to file for divorce. The way in which somebody who is a tenant in common can split away, they can't file for divorce. They have to file for what's called a partition. So each thing has different remedies, different rights. Certain interests can be conveyed to others or willed in an estate plan to others. Whereas in a right of survivorship situation, the person who is the survivor in that deed automatically gets the property. There's no probate needed. And so this is sort of eye-opening probably for a lot of people, because they just kind of go through the motions and check the box and said, okay, well, I think this is what we did on our last house, even though our life circumstances have changed. And they don't really think about it. And that's okay until you really need to think about it, until one of these life consequences comes up and catches up with you. And you can always change title down the road if you want to put property in the trust. You want to change the way in which you arrange things with your investor buddies. Boyfriend and girlfriend ultimately get married. Well, then they want to change it from either joint tenants with right of survivorship to now community property. So certain life events are going to trigger the need to change these things, and people should consider all of these things prior to taking title, because it's really, it really is an important decision. Now, I won't get into the tax stuff either, because there's some tax consequences. I'm not a CPA or I'm not a tax attorney, but some of the stuff has pretty significant tax consequences as well.
As people are going through the home buying process, this conversation is so important, but so many times it's kind of like an afterthought, or it's just hey, I got to check that box to keep this thing moving. If you're purchasing property here in Arizona, generally what's happening is purchase contracts executed. If you're not a cash buyer, meaning that you have a lender involved, the lender's notified of the offer acceptance. And at that point, the real estate agent is opening escrow or title. And that is the entity, the title escrow company is the entity that is having conversation around this topic. And so they might reach out to you, the escrow officer would reach out to you and say, hey, here's your opening package, congratulations. And we now need to know how you want to hold title. And this is just one of these things that people just don't know. So I really would love to include the chart that you're referencing, just to get people this kind of like pros and cons. I always tell people all the time with home loans, there's no perfect home loan. There's pros and cons to every home loan. That's kind of what you're saying here. There's no perfect 100% perfect, way to hold title. But I do think that this is an opportunity that we can just give some guidance and have people that have complicated situations, really have them reach out to you or somebody on your team to get a little bit more advice prior to just checking the box with the title or escrow company, just saying, hey, yeah, I'm fine with that, because there are so many ramifications. So what I'd like to do is, let's just take a very common scenario. Let's say we're talking about a married couple, and let's just say it's a community property state like Arizona, and let's call them a first-time home buyer. With that scenario, let's walk through community property with right of survivorship or joint tenants with right of survivorship, because those are what we see most common. Kind of just walk us through, in your opinion, pros and cons of each one of those based on this client scenario.
Yeah, so there's a couple of interesting distinctions. There's community property with right of survivorship, there's joint tenants with right of survivorship. We usually don't see a lot of married couples taking as joint tenants with right of survivorship. They want to make sure that they qualify or have community assets, okay? And so they'll take it either as community property or as community property with right of survivorship. The key distinction there, so I would say most first-time home buyers, easy for me to say, take it as community property with right of survivorship. That's what I think. I don't know. I mean, that would be my take.
Most common.
Yeah. What that allows is if one of the spouses passes away, the other spouse automatically gets the property. Okay, that's community property with right of survivorship. Same thing in a joint tenancy with right of survivorship. The surviving spouse automatically, or the survivor of the two, automatically gets that property without having to go through probate. Okay, and so we usually see joint tenants with right of survivorship when we see an engaged couple or we see a boyfriend-girlfriend situation. They want to take it as joint tenants with right of survivorship because they want the other party to have the property if something happens. So that's a little bit of the distinction we see. But then there's this other category, just taking it as basic community property without the right of survivorship. Well, that allows each of those spouses, either the husband or the wife, can actually convey their interest or will, through a will, their separate interest in the property to a child, to a friend, to whatever. And so there's a little bit of a distinction. So people sometimes inadvertently check community property without the right of survivorship when they intended always to have the right of survivorship, or vice versa. And so I would say, though, to answer your question, it's mostly community property with the right of survivorship. I typically don't see joint tenancy with right of survivorship unless it's friends or fiance, type of relationship, that sort of thing. We usually see community property with right of survivorship when it's a first-time married couple.
Well, we lend in 43 states across the country, and as you know, the majority of states out there are not community property states. So if you're purchasing a property in a state that is not community property, in that scenario, would you see more joint tenants or joint tenants with right of survivorship because community property doesn't exist?
Oh, absolutely. And some states call it something different. So each state, but it's a variation of that sort of concept where it's joint tenancy with the right of survivorship. Now, if it's a non-married couple who is taking property, so let's say it's boyfriend and girlfriend, they want to buy a property together before they get married. Let's say that they break up and one of them wants to keep the property, one of them does not want to keep the property. The biggest distinction is that they now have to go through what's called a partition action, a court-ordered sale to sell the property. If one wants to stay and one wants to sell. In the married couple scenario, that's when you see a divorce. So there's a couple of different legal distinctions that come off of the distinction between community property with right of survivorship and joint tenancy with right of survivorship. But yeah, you're right. You're not going to see this. I think there's probably 8 or so states in the United States that have community property, and so you don't see it in the other 42.
Yeah. I've seen quite often here in Arizona with people that maybe have been married before, they have heirs, or they have their separate children from previous marriages. In those situations, I've seen the conversation come about where if we're married and I'm passing, I want my half of the house to go to my heirs and not to you. And so that's just kind of another example of where you might see community property, period, not community property with right of survivorship, because I'm withholding the transfer of the property or my interest in the property to you, my spouse. That's a scenario. Does that make sense?
Totally. In a blended family situation or subsequent marriage type of thing. Absolutely. That's an important key distinction that needs to be made there, is that in that scenario, I have the ability to grant my interest to someone other than my spouse. That's an interesting concept. That's an interesting conversation as well. And so both parties need to know, okay, well, if that's what we're going to do, great. And then we need to go and take it a step further and have our estate planning documents also reflect that, so that we're not going through probate or nobody has to deal with this, whether this is an issue or not at a later date.
Let's talk a little bit about trusts. And many lenders, home financing lenders out there, will allow people to close in a trust. Just kind of walk us through that, whether you're buying cash or using a loan, the ability to close in the trust. Let's remind us why, if you have a trust, it's important to consider putting your residential real estate into a trust. If you can just give us a little insight on that.
Yeah, no, that's a really, really good question. And that comes up a lot. Basically, most people would benefit from what's called a basic probate avoidance trust. That's really what we're trying to do here, is to avoid probate for others. So if the trust now operates and owns the property, well, then the trust continues on beyond the passing of the spouses or whoever owns the property, and holds that title for the beneficiaries so that there is no need for probate. Now, trust can do a ton of other things, but for most people, it's not a bad idea to have a basic probate avoidance trust to get rid of the need to spend a couple of $1,000s in going to, or more, in probating somebody's real estate asset. And so whether you convey the property to a trust at a later date or take title directly in the trust, that's great. Now, I want to clear up one misconception that a lot of people have when it comes to trusts. A lot of people think that by virtue of a separate entity like a trust owning my real estate, I have asset protection. Like, I have the protection afforded that, if I get in a car accident, you can't take my trust property. And the answer to that is yes, you can. And so a trust, for the most part, is not creditor protected, meaning creditors can invade the trust and go after equity in the real estate, etc. There are certain types of trust, and irrevocable trust, which you have really no control over, to protect you from, but you're going to spend $20,000 or $25,000 to set something like that. So for the most part, most people just need a basic probate avoidance trust, and then they're good, because that avoids fights, that avoids needing to probate somebody's real estate asset. There's also beneficiary deeds, which are a great option as well. So beneficiary deeds basically says, once I go, you automatically get my property without having to go to probate. And it doesn't create a present interest. So if I'm a beneficiary under somebody's beneficiary deed, I don't get any right to their property right now. I can't do anything with the property. Unlike a trust, the trust actually owns the property at the time. And so the person who's granting me this beneficiary deed could change it prior to their death. But assuming they don't, I automatically get it without probate. And so that's an option as well. But most people should either have something like that, something like the probate avoidance trust, just to avoid certain expenses, just to kind of allow for a seamless transition if and when something goes bad.
Yeah, I love that. Thank you for that clarification. Let's talk about asset protection.
Okay.
Especially when it comes to investors. Lots of investors acquiring property, again, whether they're cash or whether they're leveraging it with some type of loan, they are being advised many times to close in an LLC. I'm assuming that's what you mean when you mean asset protection. Can you kind of walk us through that a little bit?
Yeah, asset protection refers to a whole host of laws here in Arizona and federal laws that allow us to keep certain assets in light of an adverse judgment against us. And so there are many, many things that you can do to protect your assets. Basically, what we're doing when we're talking about asset protection is putting these assets in a completely different sort of set of ownership circumstances. And so if you were to come after me, but I own nothing, everything is owned by my LLC, you really can't do much against me. If you have a claim against the LLC, then you have a claim against the LLC. That's separate than me. And so what we're talking about really are segregating assets to protect them. By segregating them out, by splitting them up, by kind of moving them around, we're protecting them. And there's nothing illegal or unethical about it. The laws allow us to do this. One of the key ways that people do this is if they have an investment property. If they own an apartment complex, if they own a rental property, even if they own just a short-term rental, what they'll do is they will put that property, they'll convey that property into an LLC or another investment vehicle, but mostly LLCs these days. And so if something goes wrong at that property, at that rental, well, guess what? Your liability is limited to what is owned by that LLC. All that is owned by that LLC is that property. And so if you've got multiple other assets, you've got money in the bank, you've got other properties, well, guess what? You've segregated the liability here, and your risk of loss is only at that LLC property. So that's really what we're talking about here, is moving around assets to better protect them from an adverse thing. Now, always get insurance, always load up on insurance. So people say, well, shouldn't I just get in more insurance? Well, yeah, you should. But you should also consider having an LLC, because sometimes there are some instances when insurance isn't enough. Insurance won't cover it. Insurance usually won't cover a contract claim. And so if there's a breach of contract claim against your LLC, insurance isn't going to cover that. They're going to cover accidents and those types of things. So I definitely think that there are some asset protection opportunities for people out there. The most basic of which is an LLC. There's a family limited partnership, which some people do. There's offshore trusts. That stuff gets real expensive, a little bit outside of my pay grade. But for me, when I see just an average kind of person who wants to, have a property or two, yeah, I think an LLC is a great way to inexpensively segregate those assets.
What if an investor is utilizing a traditional conforming Fannie Mae, Freddie Mac home loan to acquire that property, and the question comes up, well, Kelly, this deed of trust has a due on transfer, and my real estate attorney or my CPA advised that I should be closing in an LLC. First, important to know that most traditional conforming home loans will not close in the name of an LLC. They'll close in the trust or personal names, but not in the name of the LLC. So if we're married, we're closing, let's say in our trust, but after close of escrow, we want to transfer it to an LLC. Now we're faced with this possibility that we might be in violation of a due on transfer. Can you give me your insight into that?
Absolutely. I don't know if we're allowed to be talking about this together though, because you're a lender and I
which is why we should talk about it.
and I sometimes tell people not to worry about it. No, that's a risk. And so you're 100% correct in that the majority of deeds of trust out there will have what's called a due on sale clause or due on transfer clause, which basically says, look, you're no longer the fee owner. You're no longer the owner of title. You've transferred title to this property. You've transferred your interest. We were the ones who gave you the loan, not this, LLC or whatever. Our risk has changed. Our risk profile has changed. We're not as comfortable, and we have the right to call your loan due, meaning we have the right to say, you now owe us the remaining principal balance of $1 million or $500,000. And that is a right that lenders have, and so what theoretically could happen is if I say, I'm going to convey my property to an LLC because I just heard Patrick talk about the risks of a ceiling fan falling down on a dog or me falling down the stairs or somebody falling down the stairs, whatever. And I don't want that risk, right? And so I'm going to just disregard the due on sale clause in the deed of trust. Well, what can happen is the lender can say, we don't like what you just did. Here's a 30-day notice to now retransfer it back to you as the original borrower. And in that instance, then, what we would advise is, okay, you better listen to them. You better do it, because then they could trigger, they have the right to trigger the due on sale clause and initiate foreclosure, et cetera. But they're usually going to give you plenty of grace period. They're usually going to give you plenty of warning. And I can tell you that is an extreme hypothetical. I've literally seen one letter from a lender in probably 400 or 500 situations where people transfer to an LLC. I've seen, and I think that my viewing of this letter, or my seeing of this letter, I don't know if other real estate attorneys have ever seen a letter like this. It's rare. And so, is it a risk? Yeah, you're in technical violation of your deed of trust. You're in technical violation of your loan obligations. But for the most part, as long as you're paying, as long as the lender, is named insured, those types of things, most lenders aren't going to care. They're just going to say, thanks for the interest. Yeah. I mean, I don't know.
Well, all of the years I've been lending, and it's a few, let's say that, thousands of loans that I have helped people acquire over the years. I've had one as well where that exact thing happened, and the note was called due and payable. And exactly what you said is what transpired. So they moved the deed back to their personal names, but that was one, honestly, out of thousands. Not that I'm giving legal advice on this, because I'm not, but I think what you're saying is valid, and that's why I asked you the question. The likelihood is, it's out there. It could happen, and that's what people need to know, and they also need to understand what they're signing.
One other point is we usually recommend against somebody owning a rental or an investment property with their trust, because I know we were just talking about trust. Separate that stuff. I don't care if your trust, I'm good with your trust owning a membership interest in the LLC that owns the property, but the direct ownership of an investment property by the trust, we usually tell people not to do that. But yeah, the due on sale clause risk is very, very low. It could theoretically happen, but it's very low.
All right, we'll leave it at that.
I thought that was forbidden.
Well, we're just talking. I mean, we're not giving advice here, but I think it's real stuff. And that's why I like to have you on, because people are curious. And certainly we always want to have people go and get their own information as well and talk to their own real estate attorney or CPAs or tax advisors on all of this stuff, because every single person has their own unique footprint and their own unique risk tolerance, etc. So we are certainly not giving advice on that. But Patrick, anything else here that you feel like we should add on or readdress, or is it a wrap?
Is it a wrap?
Is it a wrap?
I think it's a wrap.
All right.
I think we got everything on that one.
Awesome. Thank you so much for joining me today, Patrick. I so appreciate you.
Oh, my pleasure. Happy to do it.
Thanks.